Now, I see this afternoon, Mr. Kimmins, you're due to be addressing us till 4:15, and then Mr. Lowe from 4:15 till 5. As it's rather a long afternoon session, we're envisaging having a 5-minute break, which perhaps could conveniently come once Mr. Kimmins has finished.
My Lords, just to pick up 3 points which were left over from this morning. Point number 1, you were after the reference from Gary Bourne's book,
yes,
which said, if anything, there is a more expansive approach to arbitrability in relation to foreign-seated arbitrations. The reference is 6970 under heading A. The second point was, Lord Kitchen asked me whether the notes in Mozambique were the judge's notes or, in effect, editor's notes, and the answer is judge's notes, and one sees that from the FSB, the other bundle, page 76. If one looks at the whole judgment, you can see that there are a number of notes appended at the end to the judgment. The third point was, what do I say is the test for a matter? And I'm afraid I can't reduce it to a lovely sentence for you, but what I can do is say I adopt the paragraphs 63 to 65 of Mozambique, because I don't think I can put it better than Lady Justice Carr in those 3 paragraphs, and I don't think even she would say it can be done in one sentence. So I hope you'll forgive me, but that is formally my submission on Mozambique. Now, we had turned to arbitrability. I had made the point, essentially, it is a tough test to show non-arbitrability. And then I was going to take you to the 2 elements of the test for arbitrability. 1, can you find non-arbitrability in a statute? Or 2, can you find it in public policy? Those are the 2 elements that we look at. And I think that's pretty much common ground, but for your note, the support for that twofold test is in our written case at paragraphs 47 to 48, and the pagination is 2059 of your bundle. And you'll see there that that 2-type test is taken from many different jurisdictions. So it's no surprise that I think it's common ground. Now, as to the scope of the statutory exception, we say that it is very narrow, and we adopt a sentence from Gary Bourne, which I'm going to read to you rather than take you to it. It's from page 6972, and what he says is this, and I quote, "In general, national courts have required a clear and express statement of legislative intention before concluding that a subject matter is non-arbitrable." That is the sentence from his book, and we say that is consistent with the presumption in favor of arbitrability and with the New York Convention's restrictive approach to the concept of non-arbitrability. And we say he is right if you look at the cases. And I want to start by looking at Fulham Football Club on this point, and that is at 3745. So you'll recall this is an unfair prejudice case, and an issue arose as to whether the fact that the relevant provision referred to the court as having a particular power meant that it was the court and only the court. In other words, was this some kind of statutory restriction? And the reference is 3745. And we're in the midst of Fulham Football Club and the judgment of Lord Justice Patton. And if one looks at H towards the bottom, you can see where he begins to address the statutory point. One can point to a number of examples of statutory intervention designed to preserve a right of access to the courts. In the field of matrimonial law, post-nuptial agreements dealing with maintenance on any subsequent separation were held to be unenforceable on grounds of public policy insofar as they purported to remove the right of the parties to apply to the court for financial relief. This reservation is now statutory, and it refers to the Matrimonial Causes Act. In relation to employment and discrimination, there are statutory restrictions on the enforceability of any agreement which excludes or limits an employee's right to the Employment Tribunal, see the Employment Rights Act. Now, pausing there, the case of Irwell, which was one of the 5 out of the 37 cases where arbitrability, it was found to be non-arbitrable. That is one of those cases under the Employment Rights Act. So Lord Justice Patten identifies 2 examples of where you have a statutory exception. Now, both of those statutory exceptions are pretty much along the lines of the language which I identified earlier this morning. Again, without turning them up to save time, for example, the Employment Rights Act reads, any provision in an agreement, whether a contract of employment or not, is void insofar as it purports to preclude a person from bringing any proceedings, etc., etc. So that's the type of language you're looking at. And you get that in the Matrimonial Causes Act, you get that in employment cases, and that is, we say, what you're looking for. And what we cannot find is examples of the statutory exception being triggered where there is language short of that. And it has been tried, because what people do, particularly in this type of case, is they say, well, it says the court, and it's a difficult area, and therefore we think that there's some kind of implied restriction on the basis of the use of that language. Well, that was exactly the argument rejected in Fulham. If one looks at 3759 and looks at paragraph 85, so here, in paragraph 85, Lord Justice Patten has left on one side the public policy point, and he's now turning to the statutory argument. This leaves for consideration what amounts to the alternative argument that regardless of any general considerations of public policy, Section 994, a member of a company may apply to the court should be construed as granting an unfettered right of access. This would have to be an implied restriction. But aside from the argument that it creates a class remedy, which I've already dealt with, Mr. Marshall also relies on a comparison between the treatment of 994 relief in the context of companies and the equivalent provisions which apply to limited liability partnerships. So he was taking a technical point of comparison to try and identify some kind of implied restriction. It was rejected. The easiest way to see that is over the page at 3760. Just above the words construction, the heading construction, you'll see, again, it cannot justify giving to the provisions of Section 994, which remain unchanged, a meaning they cannot otherwise bear. So essentially, he says, it doesn't matter that it says court. You can't start reading into that statute some kind of implied restriction. Now, Lord Justice Longmore put it even more clearly at 3761, where just above D, so between C and D, you can see in little 2, the number 2, he says, whether, if so, the 2006 Act expressly or impliedly prohibits the reference to arbitration of such matters. So that's the statutory exception. And then in little 3, he says whether, if there is no statutory prohibition of such a reference, public policy of the law of England prohibits such a reference. So those are your 2 candidates again, statute and public policy. Now, as to statute, he deals with that in 96. He says, in relation to the second question, it is clear that there is no express requirement in the 2006 Act that matters arising on an unfair prejudice petition under 994 should not be referred to arbitration, nor do I consider there is any implied prohibition of arbitration. It's true that 9941 empowers a company member to apply to the court by petition, and Section 996 provides that if the court is satisfied that a petition is well-founded, it may make such order as it thinks fit for giving relief. But the fact that a statutory power, which a court would not have at common law apart from the statutory provision, is given to the court does not mean that an arbitrator, to whom a dispute is properly agreed to be referred, does not have a similar power. Power to make awards of monetary sums as between joint tortfeasors and between those who together have acted in breach of separate contracts are given to the court by various statutory provisions, but it cannot be suggested that arbitrators are prohibited from making such awards. Such awards are frequently made. Therefore, one looks at the actual wording of the relevant sections of the 2006 Act. There is no ground for supposing that there is any implicit prohibition on agreeing to refer an allegation of unfair prejudice to arbitration. So statute, they both deal with the point, and they say this is not clear enough. And so they then turn to public policy and both find that that doesn't work either. And just to save me coming back to Fulham in the context of public policy, if I could draw your attention to the next paragraph of Lord Justice Longmore, where he moves on from statute to public policy. That's on page 3762, paragraph 97. And he says, third, does public policy prohibit or invalidate an agreement to refer to arbitration the question of whether a company's affairs are being or have been conducted in a manner that's unfairly prejudicial? Public policy does prohibit such an agreement. There, of course, could be no question of court staying any petition seeking relief under section 994 to 996, because the court would be satisfied the arbitration agreement would be null, void, or perhaps inoperative. It is this question that is at the heart of the appeal, and I would, for my part, derive some guidance from the principles set out in 1B of the 96 Act, namely, the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. To the extent, therefore, that public policy has a part to play, it can only be as a safeguard necessary in the public interest. Now, pausing there, that very same provision, of course, is in the 2012 Act. The reference is 2166. And then he concludes in 99, this is a demanding test, and I cannot see that it is necessary in the public interest that agreements to refer disputes about the internal management of a company should in general be prohibited. Nor can I see any reason why it is necessary to prohibit arbitration agreements to the extent that they, in particular, apply to disputes whether a company's affairs are being or have been conducted in a manner unfairly prejudicial to the interests of its members. So I just took you to that, so it saved me coming back to it in the concept of public policy. But I want to focus again on statute, because there's a lot more than what you see in Fulham. And again, I throw down the gauntlet to my learned friend to find cases other than the very narrow type of case, like in the Matrimonial Causes Act, where you have an explicit reference saying it's in effect non-arbitrable because you can't waive your rights. So if we go, please, to another classic example of where a statutory argument has failed, that is in Bridge House, which is at 3403. Now, just to give you the background to this case, this is a case where the claimant was struck off the register, and the defendant terminated the contract as a result, and the claimant applied successfully for what's called administrative restoration to the register. And the claimant then applied to the court for relief. And there is a provision I'm going to show you in a minute, which says that having been restored to the register, you can then apply to the court for such orders as the court thinks fit to make. So in other words, you can say to the court, I've been restored, so can you now put me into the position I would have been in had I not been struck off? That's essentially the way the argument plays out. And exactly the same type of arguments are run along the lines of, well, hold on, this is all about the court. And that is some kind of implied statutory restriction on the ability to arbitrate the question of whether relief can be given to the petitioner in arbitration to put him back in the position he would have been in had he not been struck off. So that's the context. And if you look at 3403, you can see in paragraph 23, just before the citation, the effect of administrative restoration is explained in section 1028, which states the general effect of administrative restoration is that the company is deemed to have continued in existence. Sorry, I'm going too fast, my lord. 3403, paragraph 23, and I'm just identifying the relevant statutory provision. And in little one, midway down the page in the citation, the general effect of administrative restoration to the register is that the company is deemed to have continued in existence as if it had not been dissolved or struck off. And this is the bit I'm interested in little 3. The court may give such directions and make such provisions as seems just for placing the company and all other persons in the same position as nearly as may be, as if the company had not been dissolved or struck off the register. So the question arose, well, is that arbitrable? And one party said, well, it's not. It's all about the court giving directions. And this is an important statutory function which is being performed by the court, and therefore it can't possibly be arbitrable. Held, no, it is arbitrable. This does not qualify as a statutory exception, and nor did it qualify on terms of public policy. So if one looks at 3412, you can see the analysis in Bridge House of Lord Justice Newing at 55. When considering the arbitrability of applications for relief under the Act, it's necessary to consider both whether the 2006 Act prohibits the reference to arbitration of such matters, that's your statutory issue, and whether the arbitration is precluded by public policy consideration, that's the other side. So far as the former is concerned, it is clear, I think, the 2006 Act does not itself, either expressly or by implication, prohibit reference to arbitration of matters arising on an application for relief under the section. The fact that it speaks of the court granting relief does not carry that implication. Echoing Lord Justice Mance in Whelan's, and Lord Justice Longmore pointed out in Fulham that the fact that a statutory power, which a court would not have at common law apart from the statutory provision, is given to the court, does not mean an arbitrator to whom a dispute is properly agreed to be referred does not have a similar power. And then one turns to public policy, and you get very similar reasoning to the public policy passage I showed you in Fulham. And he then says, turning to public policy, it's of significance that the parties chose to enter into an arbitration agreement, which, as I have said, considered to apply to BB2's claim for relief under the Act. Section 1B of the 96 Act explains that the Act is founded on, amongst others, the principle that the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. So again, you see them come back to that provision, which is in the Cayman 2012 Act. And in the Fulham case, Ricks LJ, agreeing with Longmore LJ, could not see why the autonomy of the parties to which the subsection gives primacy, subject to such safeguards as are necessary in the public interest, should not apply to the choice to arbitrate, i.e. to resolve their disputes by arbitration as well as to the manner in which an arbitration is conducted. Mance LJ had likewise noticed the principles of party autonomy enshrined in the 96 Act in Whelan's. Party autonomy is subject to safeguards as are necessary in the public interest, but that is a demanding test. Now, just to save coming back to it, they then went on to consider another point in Bridge House, which is essentially this, and I'm sure I'm summarizing it very badly, but the point was, the argument was made, well, these are very woolly issues, and they're not appropriate for tribunals to decide. And that was given short shrift. If one looks at paragraph 60 on the same page at 3413, nor can it be said that the issues raised by applications are obviously unsuited to an arbitrator. An application for relief under the relevant section requires consideration of what, if any, directions and provisions are just for placing the company and all other persons in the same position as nearly as may be, as if the company had not been dissolved or struck off. Arbitrators might be called on to decide comparable questions in the context of, for example, unfair prejudice or partnership disputes or a contribution claim. An unfair prejudice dispute might require an arbitrator to decide whether a company's affairs are being or have been conducted in a manner that's so unfairly prejudicial to the interests of members, and if so, what relief should be given. Arbitration clauses in partnership agreements will in most instances authorize the arbitrator to order the dissolution of the firm under Section 35 of the Partnership Act. See Lindley and see Pope. And that provision allows dissolution to be decreed where, amongst other things, circumstances have arisen which, in the opinion of the court, render it just and equitable that the partnership be dissolved. So that argument too falls on fallow ground. Now, just picking up that reference to partnership, that's very interesting because, of course, Section 35 in relation to the dissolution of partnerships is in very similar language to the just and equitable winding up. If one looks at 2543, you'll see Section 35. On an application by a partner, the court may decree a dissolution of the partnership in any of the following cases, little f, whenever in any case circumstances have arisen which, in the opinion of the court, render it just and equitable that the partnership be dissolved. Now, it's very interesting to see where the law has gone on the arbitrability of that section. And the law has gone as far as to show that an arbitrator may not just decide the question in little f on your screen, but may also order dissolution. And that is what happens in partnerships. So if you take, for example, Lindley on partnership at 7314, you'll see a reference there, I hope. And if you look at at the sentence beginning, arbitration clauses in partnership agreements, I'm reading from midway down the page, tend to be drawn in wide form and are likely to cover any dispute arising between the partners or between them and a partner. In most instances, the clause will either expressly or by necessary implication authorize the arbitrator to order a dissolution of the firm under Section 35. By way of illustration, Phoenix and Pope, the clause was in this form. Now, I don't want to take you to it now because of the pressures of time, but Phoenix and Pope sought to reconcile a great number of authorities which were arguably inconsistent. And in that case, Robert Goff looked at them all and said, well, actually, it's all about arbitrability, and there's no difficulty in relation to arbitrability of an arbitrator taking a partnership and considering that question and dissolving it. And you can see there the clause itself is underneath, and you can see Goff J was satisfied that the clause was apt to cover a dissolution claim, and after reviewing the authorities concluded there was no basis upon which it could be said that questions of dissolution automatically fell out with an arbitrator's jurisdiction. The old cases in which the court declined to allow, just lost that, questions of, you can scroll down please, dissolution to be the subject of the reference can no longer be relied on since they were decided under a wholly different regime in which the grant of a stay of the proceedings was discretionary. And to give you a recent example of a case where an arbitrator decided whether it was just and equitable and then decided to dissolve the partnership, see Patley Wood versus Brake. We needn't turn it up. It's in FSB at 31, just for your reference, paragraphs 2, 16, 29, and 30. And what you have there is an appeal.
Sorry, what bundle?
Sorry.
Further supplementary bundle?
FSB, further supplementary bundle, at page 31. And what it is a appeal from an arbitration award, and it relates, what it does is it explains that Michael Lee of 20 Essex had made an order dissolving a partnership. And we say that's quite normal these days, and Patley Wood is an example of that.
Has that ever been, is there any authority that's extended that to the winding up or dissolution of a company?
Well, my lord, other than, I'm going to come on to the authorities which deal directly with winding up and dissolution. Certainly nobody says that the tribunal can go so far as to make the order,
No.
if that's your question, no.
Well, that was my question.
Yes, sorry, I wasn't sure which level.
I mean, there's something, one has an instinct that the fact that the company is a separate legal person and that all sorts of statutory consequences flow from a winding up order would suggest it's the wrong side of the bridge, as it were.
Yes, I follow that. And I don't say for a minute that a tribunal can make an order to wind up a company.
Because a partnership is just a relationship between parties to the arbitration.
My lord, yes, but the reason I'm going there is because the language is identical. And when you're, for example, considering, is there some statutory prohibition on an arbitrator deciding whether it is just and equitable to wind up a company, the fact that it says the court has to be of the opinion is neither here nor there. Otherwise, that would have been a complete answer in the case of a partnership as well.
The paragraphs in Patley Wood that you wanted us to look at were 216 and
216 and 29 and
29,
30.
29 and 30.
They simply record the fact that that's the order that was made. Now,
But it may be that the meaning of the court takes its flavour from its context.
I follow that, my lord.
And that in a context where only the court can make a winding up order, when it said if the court is of the opinion, it might not be an enormous leap of faith to think that also means only the court.
Well, my lord, that's an argument, which let me show you a number of other authorities which touch on the point. But
before you do that, Mr. Cummins, can I just take you back to Bridge House for a moment?
my lord, yeah.
And ask about the precise allocation of functions in the result of that case?
So it's my fault, I'm not sure I understood you.
Restoration to the register and orders made consequential on
Yes.
that, which could be made by the court, application could be made to the court. The company back the register and the consequential relief could be ordered. And what I don't understand from your summary of the case is which body actually exercised which function.
My lord, the answer is this, when you are going for administrative restoration to the register, that is done without the court. So you do that yourself, and so there's no court order, and that's administrative restoration. That having been done, you then have the ability to go to court to ask for relief. And the court says you don't have to go to court, you can go to an arbitrator, despite the fact it says it's the court who provides that particular relief.
So what was the consequential relief that was awarded by the arbitrator in that case?
I'm not sure I can tell you the answer offhand, but it would have been something along the lines of to put them in the position they would have been in had they not been struck off. That's the question which the arbitrator would have been considering.
Positive or objective effect, binding on
Yes, yes, absolutely, absolutely. And there's, I mean, there's just one other point while we're on Bridge House. There is another provision.
It may be quite important for you to show us what actual relief they were asking for, but I can well understand that if the relief being sought was entirely confined to the relationship between parties to the arbitration agreement, that's one thing. But if it had any wider consequence, that would seem to be something quite other.
My Lord, I'll find out the answer to you, but I do recall that the issue was whether it could seek relief to the effect that the contract should not have been terminated, because the defendant had terminated...
That's the contract between the arbitrating parties.
The defendant had terminated the contract on the back of...
Yes, I think we see that in the head note at
Yes.
3395.
Exactly, that's just what I'm reading as quickly as I can.
So it didn't have any obvious third-party consequences.
I'll need to double-check that, my Lord. But just one other point arising out of Bridge House, and relating to procedural complexity. There is another type of application that you can make whereby you go to the court to be restored to the register, and which is in a slightly different, under a different section. You can see that on 3403 as well. We looked at, midway down the page, one provision, which was 1028. You've got further down in paragraph 25, 1032
Yes.
of the 2006 Act. So there you go to court and get yourself put back on the register. And then the same question arises, well, what happens then? Do you go off to the tribunal? And if so, the argument was made, if so, isn't that a bit silly? That's what they said. They said, it's a bit silly that you go to court to get put back on the register. And then you have to go off to arbitration to work out the consequences. And that argument was run. And Lord Justice Newey says, well, tough. It's arbitrable. It falls within the scope of the clause. And therefore, that's not a good point to take. And you see that in paragraph 63 on page 3414. Where at 63, you'll see, third line down in 63, I accept too that referring to arbitration matters under 10323 could produce procedural complexity. Section 10323 applies only where an order for restoration is made by the court. The company in question would necessarily, therefore, have been the subject of an application to court. That being said, it might be thought simpler to leave the court to deal with any consequential relief under 10323. If needs be, however, the court proceedings could be stayed to allow for an arbitration, and like Sundaresh Menon CJ and Tomalugan, I do not consider that procedural complexity will of itself generally be capable of giving rise to non-arbitrability. So just in passing, to save me coming back to that, because I'm going to come back to...
Is that again addressing the consequence of
My Lord.
Contract should have been terminated
My Lord, yes.
between the parties to the arbitral agreement?
I think that's right. On top of what I've shown you already, you've obviously got Section 26 of the Arbitration Act in Cayman, which I showed you right at the beginning. That's the statutory provision which says the fact that it says court doesn't provide you with the answer. On top of that, it's interesting if one looks at all the cases in all the jurisdictions in which it has been held that unfair prejudice petitions and winding up petitions are arbitrable. And looking at the language which the relevant provisions, statutory provisions, use in those jurisdictions. And I'll show you in a minute a document which brings them together, which is in the annex to our written case. But the point I'm going to make is this, is that you can see throughout those statutory provisions endless references to the court must be satisfied that, or the court is of the opinion that. And in all of those cases, it was held, well, so what? That has no bearing on the issue of whether an arbitrator can make the same order. And in all those cases, it was found that the arbitrator could make the order, and therefore there was a mandatory stay. And it's a long list. And I think the easiest thing to do is to go straight to it. It's at 2085. And this is attached to our written case. And what we do in this table is identify all the relevant provisions in the left-hand column which deal with unfair prejudice petitions, and all the relevant provisions in the right-hand column which deal with just and equitable winding up petitions, and look at the language and then explain what happened in the case, what the decision was. So just to give you an example, if one looks at 2084 and looks at Australia, you've got Corporations Act 2001, section 4611. The court may order winding up of a company if the court is of the opinion that it is just and equitable that the company be wound up. That's the Hydrox case that we looked at earlier. Held, the Federal Court of Australia granted a mandatory stay of the winding up proceedings under 2331A and 4611K of the Corporations Act in reliance on an arbitration clause in a joint venture agreement. The only relief sought by the petitioner was a winding up order. So that's a classic example of why that language simply doesn't ever go so far as to prevent something being arbitrable. And if one looks on the left-hand column of the same page, you'll see, for example, in the Corporations Act 2001, section 2331, the court can make any order under this section that it considers appropriate in relation to the company, including an order that the company be wound up, etc., etc. So every single case in this annex has similar language along the lines of if the court considers it just, if the court considers it just and equitable, if the court is satisfied. And these are all remedies under the unfair prejudice petitions statute or the just and equitable winding up petitions. And in every single one of them, the court said it is arbitrable. So in not a single case was the fact that it refers to the court or the court is of the opinion that relevant to that point. And that is because it comes nowhere close constituting what is required for a statutory exception to arbitrability. And if one scrolls down to 2085, you'll see you've got Canada, you've got the same provisions, you've got Cyprus on 2086, the same provisions, and so it goes on. The table is about 7 or 8 pages worth, and in every single case you will see the same language, and in every single case, in the right-hand column, the winding up petition was found to be arbitrable, save for the fact that the court could not make the final order. So everything underneath was arbitrable, and as a result, a stay was granted.
Well, I'm just wondering how far you're going. If you look at the first provision you took us to, 4611, the court may order the winding up. If the court is of opinion that it's just and equitable, the company be one. Now, are you saying the effect of the arbitration could be to take away from the court the question whether it's just and equitable that the company be wound up?
Well, that depends on which of the analysis you adopt. So if you adopt what I call option 1, which is that matters 1 and 2 are arbitrable, then these words have no bearing on that whatsoever.
No, I appreciate that.
Because on that hypothesis, the court is, and only the court, is considering whether it's just and equitable. If it's matters 3 and 4 as well, then at that point, we say, yes, it's arbitrable. And I'll come back to this to explain how it would work in the context of matters 1 to 4. But you would go to the tribunal. The tribunal would decide, 1, whether the underlying relief is made out. 2, whether it is just and equitable to wind up, and there's no difficulty with the fact that it says the court. 3, whether a lesser remedy is required. And if all of those are answered in a particular way, that it then necessitates the petitioner wanting an order, and it may or may not be, then the petitioner goes to court. And that's how matters 1 to 4 work, assuming that that's the correct analysis.
Yeah.
And, I'm going to come back to that.
Yeah, yes, I mean, obviously, you'll appreciate that normally if Parliament requires if Parliament requires a particular institution to be satisfied of X or of the opinion that X before something can be done, then it has to be that institution's appreciation of the situation that is determinative.
But I think my point in a nutshell, my lord, is that in the context we're looking at, we have case after case after case which proceeds on identical language. And it says the court must be of the opinion. And in every single one of these cases, the underlying arbitrable issues, the underlying issues are arbitrable.
Yes, well, you're drawing a distinction between the underlying issues and the issue focused in the statutory provision.
Well, yeah, I'm going to come back to that because there is support in the authorities in the right-hand column for the proposition that not only can the court decide the underlying matters 1 and 2 in our case, but also matters 3 and 4. And I'll come back to that. But the starting point, the easy bit, we say, is matters 1 and 2.
Yeah.
They are
But
obviously
you know,
arbitrable.
beyond insolvency law, it's pretty fundamental. If it said, for example, the Secretary of State may order the winding up of a company if the Secretary of State is of opinion that it's just and equitable, that nobody else could take those decisions.
Well, my lord, that's not an example that I've considered, but we have the answer in this context because we have case after case after case.
I mean, they're not cases that are binding on us, they're not cases that are of particularly high authority for the most part.
My lord, yes, but I don't think there's a case the other way on this point. Every single case that there is on this issue is one way, as far as I'm aware. I don't think there's any decision anywhere where they have said, in this context, oh, my goodness, the fact it says the court means an arbitrator can't do it.
Well, the only point I'm raising is that your issues 1 and 2 don't raise a constitutional question, which is raised by your issues
My
4
lord,
anyway.
I take that on the chin, and I'm going to come back to explain how we say they work. And I take on the chin that intuitively it is more difficult to say 3 and 4 are also arbitrable. I understand that argument, and I'll come on to address it. And in many ways, in some ways, we don't mind much, in that all we need is matters 1 and 2 to be arbitrable. And if those are arbitrable, the rest is the subject of a discretionary stay in any event. But I will come on to address to you how it can be right, which I think is what you're asking me, that matters 3 and 4 are also arbitrable. And I will come on to that. But at the moment, I'm just looking at the scope of the statutory exception, and I hope I've identified all the myriad of cases which have identical language and which it has been held that either the underlying issues are arbitrable, and we say that's easy, but in some cases as well, matters 3 and 4 are also arbitrable. And there's about 3 cases which go the extra stage and say 3 and 4 are also arbitrable.
Yes,
And
I think your point is, even if the cases aren't, some of them are at first instance, some of them at Court of Appeal rather than Court of Final Appeal, your point is that there is an international consensus on the matter,
My lord, yes.
at least in relation to issues 1 and 2,
My lord, yes.
and that if we should approach it by reference to principles of broad acceptation.
Exactly right, my lord. And if the contrary is true, then every single one of those cases is wrong in every single one of those jurisdictions, because a fatal flaw in the decision is that the court should have said, well, because it says the court is of the opinion, that's it, that's game over. And therefore you can't decide any of the issues. That's what my learned friend is saying. And you would have to find that the whole lot are wrong.
It's not what the cases that it's not what most of the cases you've taken us to so far have been saying. And they've been saying that you can identify matters which are capable of arbitration, even if at the end of the day the final issue remains a matter for the court.
My lord, yes, and that's matters, which is a slightly different point. You have to get through matters first.
Yes,
within
yes,
section
yes.
4.
Or, yes, matters which are arbitrable.
Yes. And then you come on and ask, is the matter, which is within the scope of the arbitration clause, arbitrable? And if that is not arbitrable, if that matter is not arbitrable because the statute uses the phrase, in the opinion of the court, or the court may issue a winding up order, if it follows from that language that the underlying matters are not arbitrable, then all these cases in every jurisdiction are wrong. And you are faced with the difficulty that every single case in every jurisdiction which we have would be wrong, and there are no cases going the other way. And so I do say, on the back of Lord Hodges' point, that in circumstances where you are having to look and construe Clause 4 in a manner which is in accordance with accepted principles, because you're looking at a New York Convention provision, we say it would be a bold step to say they're all wrong, and English law is going to go out on a limb on the basis of that language. So, my Lord, I hope that answers your question. But I've dealt with the statutory exception, and I do rely on the entirety of Annex 1, which is case after case. Then one has the public policy exception, and my learned friend runs a much narrower point in relation to public policy, which I'll come back to. But that, again, is the subject of lots of cases which are authority for the proposition that the court does not lightly conclude a matter to be non-arbitrable. It is a demanding test. It should be narrowly construed in the same way as those provisions relating to enforcement. And there is a case on the enforcement provisions under a New York Convention case where Lord Justice Hamblin said that in relation to enforcement, public policy should be approached with extreme caution, is the language he uses. See the RBRG case, which is at 4152. So that's public policy. And I showed you when we went to Fulham and to Bridge House, the two passages where, first of all, Lord Justice Patten, and then Lord Justice Longmore, and then Lord Justice Newey in Bridge House dealt with the public policy point. And you'll remember that in each case what they said is, well, let's start with the New York Convention, look at that provision, which says it's only if it is contrary to public policy, otherwise you enforce the arbitration agreement. And as a result, they gave a very narrow analysis of the public policy exception. So what are you looking at when you are looking at a public policy exception? Do the cases provide any clues? Not much, but you do get Lord Justice Patten in Fulham, who says at paragraph 40, and I think it's most easily seen if one goes to just to 2061, which is in our submissions. And you'll see that he says, he asks whether it engages, and this is paragraph 53, whether it engages third-party rights or whether it represents an attempt to delegate to the arbitrators what is a matter of public interest which cannot be determined within the limitations of a private contractual process. So that's what you're looking for. And that brings me on to the next topic, which is, well, what about procedural inconvenience and remedial inadequacy? And those are two phrases which have been coined in the Tomalugan case. And what the court there did, and this is important, is consider the clash between party autonomy and the need to implement arbitration clauses and procedural complexity and remedial inadequacy. And they said they are pushing in different directions to some extent. And the key point to emerge from that case and from other cases is that procedural inadequacy or complexity is of little or no relevance to the issue of arbitrability. It is to muddle 2 points. Arbitrability is a much narrower concept, and it does not avail you to say, if I implement this arbitration clause, it will cause procedural difficulties. And that is exactly what Tomalugan says is the wrong approach. That does not go to arbitrability. And what the courts do instead is they grant a mandatory stay, as they are obliged to do, of the relevant part of the legal proceedings, and then exercise case management directions to try and minimize difficulties. And that's the way it works, and one can see that most clearly from Tomalugan itself. Can I ask you to turn up 6617? Now, this, in a nutshell, we say is the answer to this appeal on the question of arbitrability. And I can't put it better than Chief Justice Menon in paragraph 2. And what he's dealing with here is the inevitable clash. These appeals raise issues concerning the arbitrability of disputes over minority oppression or unfairly prejudicial conduct, as well as the proper approach to adopt when dealing with potentially overlapping court and arbitral proceedings. They draw out a tension that will mount as commercial transactions and the disputes which they spawn grow in their sophistication and complexity. The tension is one that is likely to arise whenever disputes straddle court and arbitral proceedings, with the two sets of proceedings engaging common, although not necessarily identical issues and parties. The tension lies in the court's desire, on the one hand, to avoid the complications inherent in having to resolve a dispute across two different fora, and on the other hand, its recognition that it must conform to the statutory mandate laid down in Section 6 to direct that any dispute concerning a matter which is the subject of an arbitration agreement governed by the IAA is to be resolved by arbitration. Where these two considerations pull in opposite directions, the latter necessarily prevails because of the mandatory terms of Section 6. The question which then arises for the court is how it can best manage the proceedings that it has control over in order to ameliorate the complications that are bound to arise by reason of the overlapping proceedings. Now, we say that is the answer, and we say it has to be the answer as a matter of first principles. I'm going to come on and show you different passages in Tomalugan where they explain that. But take a step back, my lords. If the position were otherwise, it would be intolerable. And the reason is this: you would never know whether a matter was arbitrable or not. It would all depend on a case-by-case analysis of the extent to which inconvenience might be caused and the extent to which that inconvenience might be ameliorated by case management. So if that is what renders something arbitrable or not, then everyone's going to get themselves in a terrible muddle. And in short, mandatory stays under the New York Convention would become stays which may or may not be granted, depending on the possible levels of inconvenience caused and whether the court could come up with an idea to minimize inconvenience. That is not a mandatory stay. It becomes a discretionary stay. And that is exactly what the New York Convention says should not happen. Now, that is the underlying thinking behind Chief Justice Menon in Tomalugan. And if I could just take you to a couple of other references.
Just before we go there, do we have the text of Section 6 of the International Arbitration Act and what its equivalent would be in Cayman?
My lord, yes. The Act is, hold on, so hold on, we've got 6623. And there you have Section 6.
Ah, yes, thank you.
Notwithstanding Article 8 of the model, or where any party to an arbitration agreement to which this Act applies institutes any proceedings in any court against any other party to the agreement in respect of any matter which is the subject of the agreement, any party to the agreement may at any time after appearance and before delivering any pleading apply to the court to stay the proceedings insofar as the proceedings relate, and the court to which an application has been made shall make an order upon such terms and conditions as it thinks fit, staying the proceedings as far as the proceedings relate to the matter unless it is satisfied that the arbitration agreement is null and void, inoperable or incapable of being performed.
Thank you.
So, having looked at paragraph 2, which we say provides you with the answer, there was then, at first instance in this case, the judge said, well, I can think of all sorts of difficulties which would ensue if you sent the underlying issues off to arbitration and then you come back to court, and some people might be bound and some people might not be, et cetera, et cetera. A lot of them are the same points that my learned friend takes against me today. And the Court of Appeal was very clear what the answer to this was, and we say they're right. And the answer is at page 6649. 6649. And I'm afraid this is a point where I fear I have little option but to ask you to read 3 pages, for which, if you could forgive me, I know it's a long section, but this section of this judgment is absolutely critical, because all the points which my learned friend comes up with are swept up in this analysis of why remedial inadequacy and procedural complexity are irrelevant, because they do not go to arbitrability. They go to case management to ameliorate the effects of arbitrability. So I think I'm going to shut up and I invite you respectfully just to read 6649 to 6652.
Well, this was a domestic arbitration, presumably.
My lord, yes. And if your lordships finish at the first paragraph on 6653, the end of that first paragraph.
So it's paragraphs 96 to 103.
To, a little bit further, to 106, forgive me. And I do apologise for inviting you to read such a long section, but we do say it is very important. My lords, I'm horribly short of time, and so what I was intending to do was to take you to a number of authorities which apply these principles. And what I'll do instead is give you the references. But the important point to note is this, is Tomalugan is not a lone wolf. These principles have been accepted and applied time after time in English authorities, as well as others. So if one starts, for example, at Fulham, I'm just going to give you references and tell you the points that are made, because I'm afraid I'm terribly short of time. Fulham at paragraph 25 at 3741. The point that arose there is, well, if we send the dispute involving Sir David off to arbitration, then it's going to cause extra complexity because there are 2 arbitrations which are ongoing. And what happens with them? What happens if they're not consolidated? You'll end up with the petition being stayed in favor of 2 different arbitrations. Hell, so what? That is the price you pay of agreeing the arbitration clause. Procedural complexity is neither here nor there. Mozambique, paragraph 44 of Mr. Justice Popperwell at 4162, he says fragmentation completely irrelevant. Lady Justice Carr in Mozambique at 70 to 71, procedural complexity and difficulties, irrelevant.
So which paragraph?
That's 70 to 71 of Lady Justice Carr at 4163. Mr. Justice Foxton in NDK versus Huo, which is paragraphs 61 and 70 at 3974 and 3976. Bridge House, which we looked at earlier, paragraph 25 at 3403, paragraph 63 at 3414, paragraph 78 at 3416 and 3417. And just to give you an example of how powerful this rule is, you'll recall cases such as IRAS eel appeals. These are all mentioned in Bridge House at 3416, 3417. And what they say is, if it goes off to arbitration and the arbitrators don't actually have power to grant the relief that you seek at all, and therefore you lose your remedy, tough. That is the consequence of you having agreed to arbitration. And that is how far and how strong this principle is. So petition brought, or claim brought, stay sought, respondent says, well, hold on a minute, if you send me off to arbitration, I lose this case because the arbitrator doesn't have power. And this came up in a case involving contribution in a US state. And the US state didn't have the power to grant contribution. Held tough. That is the price you pay of agreeing to arbitrate a particular dispute.
So which are the cases that say you can lose a remedy right?
They are as follows. The best place to find them is paragraph 78 of Bridge House at 3416 and 3417. If you... just by way of example, if one looks at 3416, just to make this good. So here an argument was made, well, hold on, if you go off to arbitration, you're going to be time-bombed. And answer, tough. And the reason is at 3417, as Lord Justice Mayall says, but if these, in the last line of paragraph 78, but if these do prove to be insuperable obstacles to BBT, that will merely mean that its claim will fail, and not that it is an arbitrable claim. But the most famous example is the IRAS eel appeals and the judgment of Lord Justice Mustall, where it was the American state that couldn't award the contribution, held tough. So I hope that gives you a flavour of the degree to which procedural inadequacy and remedial procedural complexity and remedial inadequacy are irrelevant. And again, I throw down the gauntlet to my learned friend and say, well, you find the authorities which go the other way, because they aren't there. This is now universally accepted. And it may sound harsh, it may be harsh in circumstances where someone is deprived of a remedy, but I don't need, obviously, for the purposes of this case, to go nearly that far, because I don't say you're deprived of a remedy. I just say you have to go somewhere else first, and then you can come back and get your remedy. So those cases are a fortiori to our case, but their principle still stands. Party autonomy prevails. So just pausing there before we leave Tomalugan, it's interesting to see what they then say, having decided that it's non-arbitrable, and they then engage with the points which my learned friend makes along the lines of, well, this is all so difficult because what happens if there's a shareholder who's not, for example, party to the arbitration clause? What happens then? You go off to arbitration, you get your award, you come back to court, and one of the other shareholders says, oh, well, hold on, I wasn't party to that arbitration. I want to re-argue a point. And all these points are all dealt with in Tomalugan. And what they do is come up with imaginative ways of trying to minimize the difficulties. And you can see that from 6663 of Tomalugan. If you look at 138 at the bottom there. So what happens is so that's 6663. And what's happened is they've granted the mandatory stay against the party to the arbitration agreement. This leaves us with that part of the court proceedings in the suit which are not subject to the mandatory stay. These comprise the court proceedings between Silica Investor and Lionsgate concerning the share issuance allegation, the guarantees allegation, and the asset exploitation allegation. So there were some points even between the shareholders who were bound by the arbitration clause, which fell outside of the clause. So what happens to those? That's question one. And B, the court proceedings between Silica Investors and the remaining defendants concerning those three allegations, as well as the management participation allegation. The parties do not dispute the court's inherent power to stay court proceedings in the interest of case management, pending the resolution of a related arbitration. The only dispute is over whether, and if so, how, this power should be exercised in the present case. So what they then say is, well, you've got your mandatory stay, but now let's work out how we can try and ameliorate some of these consequences. And they do that by using the discretionary stay relating to the remaining proceedings. Of course, in our case, none of this causes any difficulty. There aren't any other shareholders. But it's very revealing to see the way in which the court deals with it. The Chief Justice Menon then, in an extraordinarily detailed analysis, beginning at 139, goes all the way through to page 6681, dealing with what the court should do, and then comes up with the following solutions. If you look at 6682. So 6682 is as between Silica Investors and the remaining defendants. So what's the court going to do to try and ameliorate the difficulty? There is no arbitration agreement between any of these parties. The remaining defendants seek a stay of the court proceedings against them as a matter of case management. In our judgment, such a position would be warranted and would have much to commend it, especially if the remaining defendants are agreeable to being bound by whatever decision is reached by the arbitral tribunal. On the other hand, it seems to us the remaining defendants' present stance of seeking a stay of the court proceedings against them pending arbitration of the management participation allegation is inconsistent with their retaining a right to relitigate in the broad sense that allegation after the arbitration. Any attempt to do so may well fall within the remit of abuse of process. And et cetera, et cetera. And then you can see what they then do at 6683. So how do they try and ameliorate the problems at 190? In our judgment, having regard to the aforesaid, we consider that the present appeal should be resolved in the following manner. So your starting point is your mandatory stay. That is non-negotiable. Party autonomy prevails. The question is then, what do you do to mitigate the issues? And if you look at little c, if, on the other hand, so assume Silica Investors decides to pursue the management participation allegation against Lionsgate, then the court proceedings against Lionsgate in respect to that allegation will be stayed in favour of arbitration pursuant to Section 6. In addition, the court proceedings against Lionsgate in respect to the remaining three allegations will also be stayed pursuant to the court's inherent power of case management, subject to the provisos set out at paragraph E below. And if you go over the page, I'll try and take this quickly because I am behind, forgive me, 6684, what they say is we're going to make it a condition of that discretionary stay that the arbitration takes place quickly. Fine. It's a clever way of dealing with procedural complexities. So they make it a condition of the discretionary stay. And they, for example, they say, should the resolution of any arbitration of the management participation allegation be unduly delayed, any party to the arbitration has liberty to apply to court for the stay to be lifted. So it's all about mitigating the difficulties, but none of them go to arbitrability, and all of them are manageable. And it's interesting that, for example, Lord Justice Patten in Fulham thought of another possibility. He said, well, another way of trying to minimize the difficulty is asking third parties what their view is. Their opinions can be canvassed. You'll remember that provision. That's at 3735 of Fulham. Now, these are all ways in which the courts seem to deal with the problem. But remember that none of it goes to arbitrability. So having said all of that, if one then turns to the decisions which are on the very question of whether just and equitable winding up petitions are arbitrable, and if so, to what extent, then you have the following authorities. And again, because of shortness of time, I'm going to take them quite quickly. You have the famous passage in Fulham. Let's just look at that very briefly.
That's the Obiter passage.
That's the Obiter passage. I suspect you're all familiar with it, and
Yeah.
if you'd rather, because I am short of time, and I want to
Just give us a reference.
Yes, reference is 3734, and the easiest place to find it is the head note. Look at paragraphs 83, 104, 106. And my learned friend says, well, these are off-the-cuff remarks, and he didn't refer to other authorities such as re-wine-ins. That's not right. It was cited in Fulham C3736. My learned friend says, well, he wasn't aware of a case called Four Pillars. Again, we say that's wrong. There was a case called Larson referred to in Fulham at 3755, which analysed Four Pillars at 6445 and said it was irrelevant. So just to be clear to my learned friend, we don't accept that any of these cases are cases which were ignored by Lord Justice Patten. They were all before him. My learned friend relies on a case called reseed coating. I'll come to that in reply if I have to, but I'm very short of time. The short answer to that point is this. It was a 1977 judgment in New Zealand given on an ex-temp basis, and it was relating to a discretionary stay, and you see a passage in that judgment where the court says the arbitrators can't be trusted to get the law right. Now, that is exactly the sort of language which was deprecated by Lord Stephen Mills, as he was then, Mills J, in the Norrie case, where he said, come on, those days are long gone. And again, I say to my learned friend, you find modern cases which go the other way. So is Fulham an outlier, or is there further support for it? There's much further support for it. It was common ground in the Privy Council case of Anzine versus Hermes. That's 5734, that you could consider the underlying issues in arbitration. You've obviously got Tomalugan. You've got the Hydrox case in Australia. That's at 7509. You've got cases in Hong Kong, Quicksilver, C6651 of Tomalugan. That summarizes the Quicksilver case very nicely for you. You've got another case in Hong Kong called Cheng Wei, see pages 5991 and following. All of these cases are just and equitable winding up cases where the courts said that either the equivalent of matters 1 and 2 are arbitrable, and all of them say that, but some of them go that extra stage and say matters 3 and 4 are also arbitrable. I'll come back to those. But all of these support, at the very least, my case on matters 1 and 2. And they're all bang on point because they're all about winding up petitions with similar language to that we have in this case. You've got a Jersey case in Consolidated Resources. That's a judgment of George Bumpus QC, Sir Hugh Bennett, and Sir Richard Collis. The relevant bits start at 6143 and see in particular 6163 to 6165. All of these and the relevant references are all in my Annex 1. So if that's an easier place to go. You've got another case in Zambia, in which I had a peripheral involvement. That's at 6844. And again, the reasoning is impeccable. They go through the various points, apply Fulham, apply the obiter in Fulham, and say, this is arbitrable. So we have Cyprus, we have Canada, on top of all those I've mentioned. So my learned friend will have to say, well, they're all wrong. The whole lot. And where, again, are the cases going the other way? They simply aren't there. And I'll deal in reply, insofar as my learned friend seeks to rely on reseed coating, 4 pillars, and rewind. On top of all those, you've got the textbooks. There's many of those. They're all in our argument. I've taken that very quickly, and I wish I hadn't had to, because they are all important, and they do all, we say, carefully go through the authorities and apply that obiter in Fulham. It is commonly accepted. And we do say that in those circumstances, it would be quite wrong for this court or any court to go out on a sally of its own in circumstances when this is all about party autonomy and implementing the New York Convention, which must be done in a way which is universally accepted. That is your starting point. Now, I'm going to go very quickly onto a couple of other points and then take you through some of my learned friend's points.
Just before you said it is put to you before you sit down. Section 4 of the Foreign Arbitration Act seems to be the basis on which the judge thought these proceedings could be stayed. It's at page 2191. And it says, if any party to an arbitration agreement or any person claiming through or under him commences any legal proceedings in any court against any other party to the agreement or any person claiming through or under him, etc. Now, obviously, a winding up petition is not legal proceedings brought against any other party to the agreement, not in this case anyway, because the company isn't a party to the agreement. Now, I can see the way Section 4 is drafted, it's ensuring effectively that this is a dispute in court between the parties to the arbitration agreement. Now, the argument has to be that that in reality, in substance, the winding up petition amounts to a dispute between the parties to the agreement. But it's a question of statutory construction, whether one can construe Section 4 as encompassing a situation like the present one. That's the first issue.
My Lord, let me try and answer that, because I just want to clarify one point. Yeah. The shareholders are party to the arbitration agreement. So FM has brought the petition. It is party to a shareholder agreement with TC. Yeah. It is the company who's not party to the arbitration agreement. Now, it is common ground that there are proceedings. The winding up petition qualifies as proceedings within the meaning of this
proceedings provision. Against another party to the agreement.
My Lord, yes, that's common ground.
Okay.
Well, let me just clarify this. I showed you at the beginning, I went at some length to demonstrate that, for example, there was a summons.
Yes, I know. I've got it all noted.
In which it is said this is to be treated as an inter parte proceeding between FM and TC. Mm. It's all about the shareholder-to-shareholder dispute. Free rider makes it absolutely plain. That it cannot sensibly be said, with respect to my learned friend, that this is not a set of proceedings between FM and TC, and it cannot sensibly be said or suggested that they are not party to an arbitration clause. The only point which arises is what is the effect of the company not being bound by the arbitration agreement, and I'll come back to that later. I'll be rather pressed, but I will come back to that.
That Section 4 can be construed as covering this situation?
My Lord, yes, and I had understood that to be common ground, and if it's not, in reply, I'll take you to the places where it's made plain that it is common ground.
The other matter I wanted to raise is really closely related to that. Winding up proceedings operate in rem, and they're going to affect third parties who have an interest in the company. Now, in the present case, because it's purely a holding company, there don't appear to be material third-party interests. But if we're not careful, what we say about the case might have a wider import. Now, would the case be the same if, for example, the company had employees who would lose their jobs if a winding up petition were granted?
Well, my lord, let me be clear on this. Let's test that proposition against the different options. Option 1 is that matters 1 and 2 only are arbitrable. Now, on that hypothesis, your lordship's argument doesn't come into play at all.
Well, it's not my argument, I was asking questions.
But your lordship's question doesn't come into play at all because the tribunal are simply deciding the underlying dispute, and it's the court and the court only who decides matters 3, 4, and 5. And so that argument doesn't cut across in any way option 1, which is matters 1 and 2. If you bring into play options 3 and 4, the way it works is as follows. The stay is granted in relation to all 4 of those matters. You go back to the tribunal, who will decide the underlying dispute, plus they will reach a view as to whether it is just and equitable, plus they will reach a view as to whether an alternative remedy is suitable on the facts of this case. Now, there you have 4 findings. Now, it's quite likely, frankly, that you're never going to get as far as the tribunal finding that the underlying dispute is in favour of the petitioner, plus it's just and equitable to wind up, plus there's no alternative remedy. But if you get that far, then they go to court, and they have this award, and they say, I have this award. I want you now to make a winding up order. Now, the parties who had argued it in front of the arbitration are issuer stopped in relation to that. But we don't say that the court at that point may not exercise its own discretion. And so the way it works is you're then back in court, and if, for example, a third-party interest became very significant, there is nothing to stop that third-party interest appearing at stage 5, when it's looking at matter 5, and saying, I'm interested in this, and I don't think you should grant the winding up order. Now, the court is not bound by what happened in that arbitration.
There's an analogy with that in the entirely separate from arbitration, where the court hears and tries a just and equitable winding up petition without advertisement for the purpose of protecting the business of the company and the reputation of the company. But if it decides that a winding up order to be made, orders advertisement first, so that anybody who wants to appear to oppose the petition then can.
But precisely, and your lordship's absolutely right, and you see that referred to in some of the authorities, in particular the shareholder ones, because they say, in terms, this is a different scenario completely. It's shareholder versus shareholder. No one's saying you have to advertise anything. So that very point comes up. But in answer to your point, we don't in any way say that if we're right on option 2, which is matters 1, 2, 3, and 4, that the court cannot exercise its own discretion at that stage when it is considering whether to grant an order, which is matter 5. Now, what I want to do very quickly, and if I do go over my time by 10 minutes, it'll come off my time in reply. But I do want to deal with some of the points my learned friend makes, because I want to try and demonstrate to your lordships why either they are all procedural inadequacies or they simply don't stand analysis. So let me just start with, for example, point number 1, which is taken against me, is this, that it's all about the opinion of the court. The language used is the opinion of the court, and that provides the answer. Now, that is said to be a statutory construction argument. If that's right, then every single one of those authorities I showed you in the annex are wrong, and English law will take, or Cayman law will take a completely different path to everybody else. That point is a bad point. All those cases have identical language, and it matters not a jot the fact that it says the court is of the opinion. And of course, the second point in relation to that argument is, even if it was a good argument, it doesn't apply to matters 1 and 2. Because on that hypothesis, matters 1 and 2 have nothing to do with the court reaching a decision on whether it's just and equitable. They are simply discrete issues which have to go off to arbitration. So the first point in relation to matters 1 to 4 is simply wrong as a matter of law, and in relation to matters 1 to 2, it just doesn't arise. So that's the opinion point. You then have what's known as the amorphous argument. And we think that the amorphous argument is rather amorphous.
Is this your rude word for it, or is it the other side?
No, this is my learned friend's argument. He says that it is an amorphous exercise. So in other words, I think the argument goes something like this. These are very difficult, issues which are quite touchy-feely, and they're not appropriate for tribunals. Now, I showed you the passage in Bridge House, and I think I used the word woolly. And I said the fact that it's woolly is neither here nor there. The arbitrator can decide it. So insofar as it's suggested that deciding, for example, whether it is just and equitable to wind up a company is something a tribunal can't do because it's too woolly or amorphous, we say, no, that simply doesn't work. Now, the next point is a timing point. And my learned friend says this. My learned friend says, all right, well, let's assume you go down to the tribunal and you get a decision on points 1 and 2. And then you come back up again, and the court, or one of the parties, tries to raise a different point. What happens then? Now, taking a step back, we're in procedural complexity territory in the first place, and therefore, in and of itself, we say it's entirely irrelevant. But actually, if one sits back and thinks about what would happen in those circumstances, we don't see this as being a real problem. And the reason is as follows, that for it to create an issue which has to be stayed in favor of arbitration, it would need to have this new point. It would need to have the following characteristics. One, it would need to be a new dispute of fact or law. Two, it would need to be a new dispute of fact or law that one party is permitted to run. Three, it would need to be a new dispute of fact or law which is within the scope of the arbitration clause. And four, it would need to be a difficulty which cannot be avoided by the agreement of the parties or by the court exercising its case management powers. Now, let me just unpick those for you briefly. And again, I do apologize for going so fast, but I'm running out of time. Point number one, it needs to be a new dispute of fact or law. It is not enough for the respondent to say, when they get to court, that argument falls within the arbitration clause, because of course it won't. If it's a mere argument, it doesn't fall within the scope of the arbitration clause. It doesn't need to be resolved. So test it like this. Assume that it is an additional factor. So for example, the claimant delayed in getting the petition to court. That doesn't raise a new dispute of fact or law which would trigger an arbitration stay. It's simply an additional factor the court may want to take into account. And we don't for a minute say the court can't take it into account.
Even if it's a disputed factor?
Well, no, only...
One can always bet that it's going to be a disputed factor. The usual one that arises is, oh, they've done it again.
Well, it depends whether it falls within the scope of the arbitration clause. You've got that point as well. But just to be clear, let's say the claimant is late. That is an additional factor. There's not a dispute of fact as to whether the claimant is late. It either is or it isn't. There's nothing to go back to any tribunal. That's simply a discretionary factor. And those problems, they don't have to go back under any circumstances. If it is potentially a new factual point, then the next point is, well, is somebody allowed to run it? And if so, on what conditions? Because, of course, permission to amend would need to be sought in order to run a new point. And at that stage, in come the case management powers, and somebody might say, well, the court could say easily, well, I'm going to allow you to run this new point, but only on the condition, Mr. Respondent, that you don't exercise your stay. And there's nothing wrong with that as a matter of the court exercising its discretion in relation to an amendment. So these are ideas which I'm coming up with off the top of my head, but you can see how they approach it in Tomalugan, and you can see these are the sorts of points which mitigate this idea that there's this real problem about having to go back to a tribunal. You might say, for example, as well, that the court might say, well, I tell you what, I'm going to allow you to raise this new point, but I'm not going to stay the rest of the petition. Okay? Because it's only, let's assume for the sake of argument, that the new point is a new point of fact, which does fall within the arbitration agreement, and therefore which would in itself trigger a mandatory stay of that point. Yeah. But it's only that point. And the court then says, well, what about the rest of the petition? And you saw Mr. Justice Andrew Smith in Lombard, and he said, well, in those circumstances, you crack on with the petition. Because you take the view that this additional point is neither here nor there, and it shouldn't be something which prevents the petition going ahead, and therefore you don't grant a discretionary stay of the remainder. This is classic Tomalugan type approach. And so all these possibilities are available. Another possibility, the court says to the petitioner, you want to raise a new point. Now, don't forget, the petitioner is already 1-0 up at this stage, because the petitioner has won sufficiently to get through to court to present his winding up. So he's won in arbitration. So, and he says, you've done it again. Now, the court might say, well, I'm going to put you to your election, petitioner. You can either proceed on the basis of what's been argued already and it's been decided in your favour, but if you want to run this new point, I'm going to send the whole thing off to an arbitration. So I put you to your election. These are all the types of approach which a court can take to minimise this possibility. And also you've got the possibility of the parties being sensible and saying, well, we'll agree. But
the ghastly bottom line, if all these wonderful schemes don't work for one reason or another, you might have to get, say the arbitration award occurred 8 months after the conclusion of the arbitration hearing. I'm not suggesting arbitrators ever delay their awards that long, but maybe it's happened. And in the meantime, the company's business has been conducted by the respondents, and the petitioner says, well, even though I've won, the court might find it difficult to decide whether to make a sort of management in the future order or a winding up order. And the petitioner says, yes, but they're completely unrepentant. They were doing it during the time you were writing, the arbitrators were writing their award.
Yes. My lord, I can't for a minute say...
And it might have to go back to another arbitration.
I can't for a minute say that there are no circumstances in which that might have to happen. Yeah. Because as a matter of logic, obviously there are. But what you're faced with is an argument that the risk, and we say it's very slim, if you think of all the steps that one needs to have gone through to get there, you're being asked to say the risk of that procedural inconvenience, brackets, which is irrelevant as a matter of principle per Tomalugan and all the authorities since Tomalugan, is so strong and it's so difficult that I'm going to render the entire thing non-arbitrable. And party autonomy is left at the wayside. That's what you're being asked to do on the back of a risk, and we say a very slim risk, of a potential issue arising. When you've got all those weapons available to you as a court, including permission to amend, including carrying on with the proceedings in any event, including putting to someone to their election, which is one of the points raised in Tomalugan. That's what Chief Justice Menon said to the claimant. He said, I'm going to give you the option to drop that point, which is the subject of the mandatory stay. So all these are available, and therefore we say it's quite wrong to suggest that that timing issue is sufficient to put pay to party autonomy completely.
You say it's a tail wagging the dog.
My lord, yes,
Yeah.
we do. Now, that's the timing point. My learned friend says, well, the remedy is bound up with the just and equitable issue, and we're not entirely sure that we understand that point, but it seems to be similar to that raised in Tomalugan. Let me just give you the reference, paragraph 96, where Menon CJ says, and I quote, the judge thought that since the nature of that oppressive or unfairly prejudicial conduct complained of in a claim under section 216 was inextricably connected to the relief that might be awarded, the arbitrability of the remedy could affect the arbitrability of the claim. Rejected. In no uncertain terms in Tomalugan, that is a classic case of arguing that remedial inadequacy renders something non-arbitrable. And they say, no, that's absolutely not enough. But in any event, we think this argument is based on the assumption that a different tribunal will decide what's just and equitable and will decide the remedy. But that's not our case, either on matters 1 or 2 or on matters 1 to 4, for this reason. If we're right on matters 1 to 2, then the tribunal doesn't decide either whether it's just and equitable or what the remedy is. So 1 and 2 is an aside. So there's no difficulty there. But even on 3 to 4, what happens is tribunal decides 1, 2, 3, and 4, You then go to court. Court will be exercising its discretion in relation to whether to grant an order, and if so, what order it is. And it is therefore deciding both limbs. So we don't see that this point arises on either of our cases, whether it's 1 and 2 only or 1 to 4. So we don't understand that point. The next point is that important protections are removed under Section 99. And the idea here is that you are protected once a petition has been lodged by Section 99 in relation to various transfers. But the error in the argument is that we don't say that you can't issue the petition. The whole point of Section 4 is it proceeds on the assumption that you have done so, and you then are the subject of a stay. So it's simply wrong as a matter of first principles. You are protected. You issue the petition, thus triggering Section 99. At that point, you then apply for a stay under Section 4, and if it's granted, it's granted. If it's not, it's not. But that doesn't deprive you of the protection you had under Section 99 when the petition was first issued. So that point is quite wrong, and obviously wrong. The next point is it undermines the need to proceed with diligence. So it's a delay point. It says, well, if you go off to arbitration, it's all very difficult in the context of a winding-up petition because winding-up petitions need to happen quickly. That's essentially the argument. It's wrong for a number of reasons. First of all, as to the risk of further delay, that may or may not be true. It depends on what arbitration rules are adopted. Some arbitrations are extraordinarily quick. Some arbitrations have time limits of 6 months before an award must be issued. So it all depends on what your agreement says. Point number 2, it's then said, well, delay is particularly undesirable for the purposes of a winding-up petition. And it refers to the practice direction, which is at 2119. But if you look at the practice, sorry, that's the argument is at 2119. The practice direction is at 2557. But of course, if you go to the practice direction and look at the very last paragraph, paragraph 5, and just for context, the suggestion is made in my learned friend's submissions. He says, well, all these arguments apply to a contributory's petition as they do to a creditor's petition. Well, no, they don't. Paragraph 5, this statement does not apply to contributory's petitions. Different considerations apply to these, and there will normally be no objection to long or repeated adjournments by consent. And in circumstances where a stay has been granted pursuant to an agreed arbitration clause, that is the equivalent of an adjournment by consent. Now, leaving all those to one side, the suggestion that the risk of delay can trump party autonomy is in itself something that has been considered time and again by the courts, and they've said, no, that doesn't come anywhere close to trumping party autonomy. Look at, for example, Channel Group versus Balfour Beatty referred to it in Lombard at 3894. Lord Mustill said, and I quote, the fact that a party now finds their chosen method too slow to suit their purpose is, to my way of thinking, quite beside the point. And again, the point is a very simple one. You've agreed to arbitrate, therefore you must arbitrate. And if the consequence of that is that there is a delay of some kind, well, tough. And I challenge my learned friend to find any case anywhere where a potential delay caused by arbitration has rendered something non-arbitrable. That's a nonsense point. You only need to look at, for example, Salford, whereby you can delay a creditor's petition by not agreeing to a debt. If you don't dispute a debt, which is subject to an arbitration clause, it goes off to arbitration. That's delay. But the reason that that's not a problem is because you've agreed to the arbitration clause. That's a point that's made in Salford. The next argument is, well, it's a remedy in rem, and it affects third parties. Well, that needs to be treated with real circumspection. First of all, if you are a creditor who is somehow affected, then you can, if you want, try and appear when the case eventually reaches court. And we don't say for a minute that you can't. And so we don't really see where that point goes. It's said that a creditor could appear at a contributory's petition. And just to be clear, we don't accept that. And the case relied on by my learned friend, Gaslog, the creditor was only entitled to appear in that case because he was invited under the advertisement to come and appear. But none of that really matters, in that on our case, the creditor is entitled to appear if he sees fit. So we don't really see where that point goes either. It's then said, well, what about this difficulty about shareholders not being bound? And there might be another shareholder. Well, one, that's not this case. And in any event, you can see the way that that is dealt with in Tomalugan. And they say, one, that does not render anything inarbitrable. And two, it can be mitigated by use of the following orders. And you can see the way they dealt with it in Tomalugan. And they invited the petitioner to invite the other shareholder to join the arbitration. And if the other shareholder says no, and then sits back and waits till it comes back to court, and then says, aha, I'm not bound, then there's an abuse of process point, which is precisely what was raised in Tomalugan. And so that point doesn't work either. And in any event, you're looking at risks of things happening, which are simply not enough to render something inarbitrable. Now, I'm going to quickly deal with two other points. The next is my learned friend's public policy argument. And he says here essentially this. He says, there is something very special about Cayman, because Cayman has a gateway to other relief, which is channeled through a just and equitable winding up petition. So there is no self-standing just and equitable remedy in Cayman. And we, in our skeleton, we said, well, we don't understand why that is relevant. What is the possible relevance of that? Why does that stop any underlying issue being arbitrable? And we threw down the gauntlet, and an argument has come back, and I don't know whether it will be maintained, but it goes something like this, and it's based on privacy, and we say it's frankly hopeless. It goes something like this. It says, public policy in Cayman requires shareholder disputes should be resolved in public. That's proposition 1. Shareholder disputes resolved in arbitration are in private, and that therefore defeats public policy. Proposition 2. Proposition 3 is, in light of that, the only explanation of why the legislature in 2007 insisted on just and equitable winding up being a gateway to the other remedies was to ensure that it's all in public courts rather than private. But you can immediately see that that is a circular argument, because it seeks to assert that it's non-arbitrable in support of the idea that it's public. So it's a classic bootstraps argument, which is in any event built on an entirely false premise, which is that it is the public policy of Cayman law for shareholder disputes to be resolved in public. Where has that come from? There is no suggestion in any authorities or texts or anywhere that we can find which suggests that Cayman public policy wants these things resolved in public. And indeed, the contrary should be true. If you want to ensure people come to your jurisdiction, you want to be able to resolve your private shareholder disputes in private. And that is the very basis behind party autonomy. And all around the world, if you were told, by the way, you can agree an arbitration clause, but if you agree it in Cayman, then you can't resolve your disputes privately. Sorry, you've got to be public. That is surely contrary to public policy, not the basis of public policy. So we're baffled at the suggestion that it is, that Proposition 1, that everything in Cayman should be in public, gets off the ground. And we say to my learned friend, where is the evidence to suggest this? And there is a case, which I'll just give you a reference for, called Camelos Partners, and a decision of Chadwick P., where there was some consideration of why it was that in 2007, when the new remedies were added to 95.3, they channeled them through the just and equitable jurisdiction. Why was that? And frankly, they slightly throw their hands up in the air and say, well, we're not sure. And the reason is there is a Law Commission report which says, well, what we're going to try and do is replicate, in effect, the old Section 459. So in other words, we're going to try and do what the others are doing, but that clearly hasn't happened, says Chadwick P. So one possibility is that they tried to do it and it was a mistake. Another possibility is that they didn't want to provide additional remedies to minority shareholders. But where one gets this idea that it all has to be in public from, we simply don't understand. So we think that that's a bad argument, but we'll wait and hear how my learned friend puts that.
It certainly, if there was such a public policy, you would have thought it might have appeared in the Law Commission report that led to the 2012 Act.
Indeed, and it's not.
As a restriction on arbitrability.
Precisely. But I mean, intuitively, it's exactly the opposite. I mean, you'd be furious if you agreed an arbitration clause to be told, oh, sorry, that doesn't work. You can't. And if my learned friend is right, you can't. The arbitration clause has no effect on a shareholder claim of that kind. So you are forced to go public in relation to a private shareholder dispute between two private shareholders who are very sophisticated and agreed an arbitration clause. So we just don't understand this argument, but we'll wait and see how my learned friend puts it. I'm running out of time. I'm going to take 5 minutes, if I may, from my time for tomorrow. 95-2, it looks like both sides take the position that that doesn't add much. I'm going to say nothing about that at that stage. All I want to say is, what about the company? The company is not bound by the arbitration clause, and therefore, what should the court do in relation to the company? We say it can do one of two things. Point number one is it could simply stay the petition as a whole on a mandatory basis, on the basis that the company is not the de facto respondent to the proceedings. And we know that from what K. Willie J. Ordered, that this is treated as inter partes proceedings between FM and TC. And therefore, K. Willie J., unsurprisingly, didn't consider it necessary to grant a discretionary stay against the company. He simply said, because FM and TC are bound by the arbitration clause, and because that they are the protagonists in this winding up petition, I will grant a mandatory stay of the petition as a whole. If you weren't persuaded by that, then there's an obvious alternative, which is to grant a discretionary stay as against the company, for all the reasons which I went into right at the beginning of my submissions. It seems crazy to have a claim against the company when the petition that you have issued is in relation to the conduct of TC and a breakdown in the relationship between FM and TC and a buyout order from TC. And therefore, the idea that one can simply continue against the company in any event when the company is not your protagonist at all makes no sense at all. And therefore, one should grant a discretionary stay on that hypothesis. I should add one other point. There is a case called Revocam, and the reference is 4341, where exactly this point came up. And if one looks at little e, it says, as for the company itself, because the company wasn't the subject of the arbitration clause, but the others were, the shareholders were. As for the company itself, Section 459 proceedings are proceedings between shareholders. The company is a necessary party, but once the respondent shareholders are removed from the battle scene, there can be no basis on which such a petition can be proceeded with against the company alone. So a discretionary stay was granted on the basis that the company was not a player in the litigation. And you'll remember all the dicta from Free Rider along the lines of, this is not hostile litigation between a shareholder and the company. It is hostile litigation from one shareholder to another. So one would grant the discretionary stay against the company. Insofar as my learned friend then said, all right, well, you grant the discretionary stay against the company, but I'm now going to completely change my petition and aim all my guns at the company instead, and therefore I'm going to ignore the buyout, I'm going to ignore the breakdown in trust between TC and FM, all those allegations, and I'm going to change change direction completely, then he could try and do that, and he could try and lift the stay, and we would no doubt say it was an abusive process. But in terms of what you need to do now, we say it's thoroughly straightforward. There is a claim between two protagonists who are two shareholders. The summons for directions has held in a consent order that it is adversarial proceedings between two shareholders, and that's the end of it. So you can grant a discretionary stay against the company, and the parties can take it from there. So that's the company point in a nutshell. There are many other points I wanted to raise, but due to the time, I've already eaten up 5 minutes of my reply. So I think the sooner I sit down, the better. So unless I can assist you further.
Thank you very much, Mr. Kimmins. Well, we'll adjourn for 5 minutes and then hear Mr. Lowe. Mr. Lowe.
Well, I feel a bit like a barefoot heretic on a bed of coals. And so I just thought I might try and get a few things out of the way by way of concession, so you don't give me too much of a hard time on these. We don't challenge the public policy in favour of arbitration. It's very obvious. We merely point out that that's not the only public policy at issue here. We also don't challenge the notion that a corporate governance dispute is incapable of being arbitrated, or is capable of being arbitrated. We don't challenge that. And we don't say that an issue, whether there has, for example, been a breach of a Westbourne Gallery understanding, or even breaches of duty, is incapable, as a matter of fact, of being arbitrated. It's the context that matters. I wanted to use up my time this afternoon by saying something about the facts. You haven't really heard very much about those. They're relevant to any exercise of discretion that you may have. It's right that you know why we're here. It's completely wrong to suppose that we're here or we've contrived a situation to get out of arbitration, because there was, in fact, an arbitration. I'm going to show you what that amounted to. And you'll see when you've looked at that how close we came, in this case, to the scenario Lord Briggs described to my learned friend of having to come back and back, and how little the arbitration actually resolved. My learned friend took you through the petition, and he talked extensively about the understanding. He emphasized that. But in fact, the main case in the bulk of the petition is about the lack of probity of the directors, who also control Ting Chuan. Their duties, for example, are set out. I mean, they're related. They're the duty not to enter into related party transactions. They're set out at page 15. And we made submissions in the Court of Appeal, which are, I'll give you the reference, they're page 734 at 737 to 8. And my learned friends were taken to those by the Court of Appeal and accepted them. They're not controversial, right? That's why they're described as uncontroversial principles relating to use of companies and so on that you closely control. The judge misunderstood this allegation. You can see that if you look at page 134, paragraph 17, and page 136, paragraph 26, because he thought that we were alleging a breach of fiduciary duty against the companies, not the directors. And when he made the comments about thinly veiled allegations and obtuse pleading, you have to bear in mind he misunderstood the case. He also misunderstood what we meant by the Westbourne Gallery understanding. He said it was, in fact, unarguable. And he says that at paragraph 27, page 137. And the Court of Appeal rightly rejected the criticisms of our pleading on that basis. And there's no appeal against that. The understanding, which is really not our primary case, was essentially an explanation for the behavior that had gone on until 2012. It was the directors who needed the benefit of that understanding to explain the what would otherwise would have been wholly inadequate disclosures that they made in the period up to 2012. Because, and that's what the Court of Appeal meant at page 173, paragraph 54, when they said it was really the other side that needed the benefit of the understanding. If our case on the related party transactions was correct, that was inevitably going to be their response to it. And if it came to a stay of the case against Ting Chuan, and I'm going to come back to this, we would want to continue against the directors with their related party transactions. And I'll explain why and why that ought to be appropriate. Can I just show you something about the undisclosed and unapproved related party transactions which occurred after 2012? Between 2012 and 2017, December, there was almost no disclosure, and there was nothing really that explained what was going on to us about related party transactions, because the accounts no longer identified them. There was a change of accounting treatment. I'm not attaching blame for that, but certainly we weren't told as a result what the related party transactions were. There was also a period of 4 years in which there were no board meetings. A request was made at a board meeting in March 2018 for disclosure of related party transactions, and the reference in the evidence to that is in Mr. Ogawa's second statement, which starts at 1998, and you'll see at page 2013, paragraph 46, that he deals with the request. But it was that, the failure to respond to that, which led to the inspectorship application. You remember that there was an application for inspectors. That was made on the 21st of May 2018, and it's referred to in the petition at page 24, paragraphs 72 to 73. That then prompted disclosure of what's called the related party schedule, which is referred to in the petition at paragraph 76 and 78. But again, those schedules were not full disclosure because they didn't tell us what profits were being made or shunted to the related parties. A summary of this is at page 31 in the petition, paragraph 102. Now, this was and remains an ongoing problem. The company was expected to grow substantially, and if we look at some of the documents that were disclosed, perhaps we can start at 1316 in the bundle, electronic bundle. Sorry.
This is a record of the board meeting in November 2018.
1316, I might have given you the wrong page, so just forgive me a second. Yeah, no, that is the wrong page. The schedules start at page 1260, and sort of landscape format. And you can see that at 1260 you get a summary of the total purchases from related parties from 2011-2017. And this is an analysis of the schedules that were produced. It's an analysis, I think, by Deloitte of this information. 2011, 161 million US dollars related party transactions. By 2017, $706 million of related party transactions. In the next page, 1261, you can see the related party purchases as a percentage of total purchases, which is an astonishing amount.
Is this confidential?
So,
Is this confidential, these details?
no, this information, well, this is confidential in the sense it was disclosed to us once we'd issued the inspectorship application.
Is it a public domain now?
Well, in the sense I'm reading it out, and I read it out in the Court of Appeal and to the judge, so it's public in that sense, yeah. So you can see a massive increase in those transactions. You can see a very high proportion on page 1261. And then if you go to page 1264, there you have the figures again of related party transactions in the top table. You have total revenue at the top of a billion, and you can see the RPTs as a percentage of that, very high. You can see that the gross net profit margin, despite the fact that you've got a revenue of a billion, you've got profits for the year of 5 million. So you've got a very anemic profit margin, 0.5. And then you can have, on page 1265, you have some other metrics. And there was a comparison of these figures to other sort of comparable businesses. And if you go to page 1980, this is, in fact, starts at 1964. It's the affidavit of I think he's a partner in Deloitte in China, 1980, at paragraph 430, and over the page, he compares this to other operators and concludes that he can show that the figures of CCH are surprising in terms of the volume of related party transactions and the anemic profit and the size of the business. So, pausing there, although FMCH doesn't have to prove this, and it's had no discovery at this stage of the related party transactions, it's gravely concerned that these transactions are shifting profits and have been shifting profits on an increasing level up to the issue of the petition to the related parties. And it's worrying to us that for a business of this size, and it's had this much investment and these many stores, the profit is so anemic. And it getting bigger, which it seems to be doing, and in fact, the court below was told it was going to continue to do after the presentation of the petition, doesn't resolve anything. I mean, if we thought that the petition when it was presented prevented this sort of activity from going on, and I ask you to look at page 248 and page 257, which is part of the skeleton, I think, that was produced to Mr. Justice Caverley.
257.
257, paragraphs 18 and 19. And you'll see the plans for the company post-presentation of the petition didn't suggest any let-up. After the inspectorship application was issued, we also, I think it was withdrawn on the basis that they were going to give us a lot more documents so that we could look at the transactions and decide whether or not they were fair and so on. So we agreed this, and a minority director was told he had to go to Shanghai, and of course from Japan, to carry out a physical inspection. Before doing that, he had to sign a confidentiality agreement. He wasn't allowed to show the petitioner what was going to be disclosed. And he wasn't allowed to take any copies. And when he carried out the exercise, it's perhaps easiest to give you a visual illustration of what he saw. There's some grainy photographs, which you can see at page 1409. There were something like 76 lever arch files and numerous boxes, and he says, in no particular order, jumbled up largely, even though there was an index which starts at page 1397 and finishes at 1408. One of the files, and there's a breakdown of it, was the contracts for the related parties, but they don't tell you anything about the level of profits that are being shunted onwards. The director involved recorded the visit, and you can see that at 1330, page 1331. Letter starts at 1330, paragraph 5 on 1331. He says he looked at all these boxes, notes on related party transactions, as I say, from the individual accounts for the year, these were missing relevant documents, all or material parts of all the supporting source documents, individual contracts, terms of business, due diligence reports, emails, and so on. And repeated that those requests were made at board meetings. And he also complained at the next board meeting. If you can see that on page 1323. And the board meeting starts at page 1316. That's November 2018. So that's post the presentation of the petition. He complains about this at 1323. He's Kiriyama. And then again at 1324, again halfway down the page, and you can see what Mr. Way says. He says, well, we got you 100,000 documents, and shame you couldn't stay a few weeks to look at them. FMCH made it clear it was not prepared to agree any of the expansion that was clearly, the court was told after this, was going to carry on without this consent. I think you can see that on page 1322. Director Kubo, about the second person from the bottom, Chairman Wei wanted to get permission to go into Nanjing, important location. 3 FMCH side directors against it. We're sorry we can't support it. We still haven't had the details of related company transactions disclosed to us. It means we have been in an unusual situation. We cannot properly carry out close examination into business plan profitability. Given the situation, we don't believe we're in a position to actively seek expansion of the business. And if you go to page 1324, he states in terms what FMCH expected at the top of the page by way of disclosure about 4 lines down. What I want to know as a CCH director is the interest between those related companies and all of your 4 TC side directors. That's the first one. Second, I want to know how much profit all of you 4 directors are gaining from the related companies. Thirdly, I want to know if the transactions with the related companies are carried out most beneficial conditions to us. CCH, for these 3 points, no information has been included in the materials exchanged so far. We would like for the 3 FMCH directors to disclose this information to the CCH director. We can participate in the administration, and so on. And eventually, that doesn't get anywhere. We don't get the disclosures. The petition's presented to stop the misconduct. We have a credible basis for believing it would continue. Potential economic consequences of the misconduct are so large over these years that it is unclear how a court could address this on a purchase order, a buyout order. The Cayman court doesn't have the ability of the English court to value shares in a compensatory way, not obviously. It's never actually made a buyout order in any case. I mean, this would be the first. It seems horribly complicated for it to be asked to do that. It would be rather like those proceedings that you've already had some involvement in the Privy Council, the ones that we call the merger disputes, the 238 cases, Shanda Games, and so on. And in any event, we've commenced derivative proceedings because we would hope a liquidator would take those over, but a buyout wouldn't compensate us for related party transactions if they have been as damaging as we fear they might have been. The delay since the presentation of the petition is bound to have massively prejudiced us. I mean, it's not only the delay, the ordinary delay in the ongoing activity, but we fear that the effects of the lockdowns in China and COVID have made matters much, much worse in terms of profitability. Now, when we presented the petition, Ting Chuan TC indicated a number of affirmative defences, and these were all the subject of the dispute notice that was then served on us. It's 1361. You weren't taken to the arbitral papers by my learned friend. I'm sure he would have done if he'd had more time, the notice starts at page 1363, and it's dated 29th of October, so shortly, 3 weeks after presentation of the petition. The details of the allegations are at 1364 to 1365. The filing of the petition and material breaches of the SHA, clearly without merit, breach of the provisions on dispute resolution, without getting board approval and so on. We made secret arrangements with another company, and then you can see that we obstructed and impeded the daily operations of CCH. And then there's some particulars set out. We didn't approve the business plan, and we made the inspector's application, the application to wind up. We objected to expansion and so on. So we then have the ICC being engaged after, there's an application for arbitration at 1367. And then the terms of reference were agreed and submitted to the tribunal at 7357, and the relevant allegations at 7358. And you'll see at 7358, sorry, not 58, sorry, it's, yeah, terms of reference 7379, and the relevant particulars of the claims that are going to be, the tribunal is going to be asked to look at 7385, which include those in the notice you just saw, going over the page, 7386, and then 7387, they set out what we were saying up to a point. We then have the ICC award being made 4 years later, and we have discovery, we have pleadings in the tribunal, we have oral testimony, evidentiary hearings, and the like. 4 years later, and just so you can see the cost of this, all the allegations against us were dismissed. A number of findings, I'm going to show you a couple of the findings that were made that were against Ting, Chuan and helpful to us, I suppose. The costs of this exercise, you might just like to look at page 7473. Our costs were in excess of 14 million. The tribunal was nearly $1 million. They said, and they didn't give a breakdown of it, but we don't believe it was as little as 10 million. And they're going to have to pay the costs. They're not going to bump up their costs. But, you know, we've got costs here of 25 million, 4 years, probably much more. At 7410, paragraph 60, you can see all the claims, that issues that were going to be dealt with are set out. All these were dismissed. The veto of the business plan, if you go to 7458, sorry, just check the time, yeah. Allegations, other complaints, allegations spanned a number of years. And then they deal with the minority directors, requests for documents. 7462, I think, is maybe an easier place to see it. Anyway, they dismiss, I don't need to go through the detail of this. What is much more interesting about the way they deal with this is that at the end of this process, when everybody's been screaming at each other, and the other side have accused us of bad faith and the rest of it, we had already said we wanted a divorce. The tribunal finds that that's actually what the other side had told us too. Can I just ask you to look at a number of areas where they do this? 7441, paragraph 126, word divorce has been used by the parties to describe the irretrievable breakdown of the relationship between the parties. Word is telling, breakup of partnership can often be as painful. And then we go to I think might be worth looking at 7429. So this is slightly out of order. The point I was making a minute ago, paragraph 104, about 6 lines down, sentence beginning, claimants have been forthright in their condemnation of the respondents' witnesses and evidence, although the respondents have been more reticent, their mutual attacks show clearly the parties' severe loss of trust and confidence in each other. This mutual mistrust is unfortunate. Every turn the parties are too ready to believe the worst of each other. And then if you go to paragraph 7451, page 7451, paragraph 143. We turn to the claimant's demand for divorce in early 2017. Now, I should just say something. There was a dinner in 2017 between the president of Mart, Japan, I think it was, and Mr. Wei, the fourth brother. And at that dinner meeting, which is, I think, also referred to in the petition, we alleged that he asked for a divorce, and he was insistent that he would do this on his terms. We'd either give up quite a lot of our royalty, it's the only way he would continue, or we'd have a divorce. It should now be, and what happens is he denies that in his evidence, in the inspectorship. And we now get to the tribunal and the findings it makes. This should be now viewed in the light of our decision that up to that time there had been no breach of Article 11. We're also of the view that there was no breach of Article 9. Mr. Wei's evidence is that the TH group wanted the demand to be taken seriously by the response on the face of it. Claimants were belligerent, apparently convinced that they were in the right, and Itochu and completely in the wrong. The claimants' terms are set out in their letter of 8th of February, contained 2 options. Option A was for divorce Korean style, which we were told meant that the TH group alone should continue to run FM in the mainland. Option B, in lieu of a divorce, they wanted a reduction of the royalty arrangement with a cap of 20 million. The letter was preceded by a dinner meeting on the 24th of January, at which we believe the same terms were disclosed orally. Again, it's unnecessary to go into detail. We think it's fair to say claimants wanted a divorce, but apparently on their terms only. Then in the footnote they say, there's a detailed record of the dinner meeting prepared by Mr. Takashima, dated 25th of January. Claimants have produced no record. We've no reason to doubt the accuracy of Mr. Takashima's note. Mr. Wei was recorded to say that the past several years have seen the shareholders of China FM, CCH, having no faith in each other and seeing each their own visions. And then you go over the I think, carry on. We believe it would be reasonable to consider the claimant's complaint about the respondent's conduct after the divorce demand in the light of the deterioration of the parties' relationship following claimant's demand for divorce. Respondents saying their conduct should be viewed in that context. And they agree. The claimants don't wish the winding up, this is 7452, to continue, hence their continuing efforts to put a stop to it. The application for leave to appeal to the Privy Council is pending. Neither party said the relationship could be salvaged. So the dispute is over whether the respondent's allegations in support of the petition and the relief sought therein should be resolved in the courts as the Court of Appeals decided, or the respondent's allegations should be first dealt with by arbitration. So we've got a situation where we believe there was, and there's evidence to show, that the related party transactions were massive, that there was a complete breakdown in confidence between the parties, that both parties are clamouring for divorce, that when Lord Justice Patten says in Fulham, well, they can come back and if the arbitrator thinks that they have a basis for winding up, he can say so. And what clearer indication could the arbitrators have given that there should be a winding up in these proceedings? They haven't dealt with the allegations, but they clearly accept that the parties don't get along. And that's part of the background. That's why we're here. We spent a lot of money getting here. We've had a long delay. And it's not true, and it's not fair to say that we've shirked in arbitration because we just don't like it. We've had one. It's been very expensive, and we now want to get on with the divorce. So I don't know how that deals with time. I've got, I think I've got, yeah. I was going to deal with non-arbitrability just at the moment quite shortly. The question of construction is dealt with in our case at pages 2096 to 2098. There's not a huge amount in paragraphs 9 to 15. There's not a huge difference between us, but of course the emphasis is quite different. I would just like to perhaps remind you that you're never going to find an arbitration lawyer who tells you about the limits of arbitration. The non-arbitrability doesn't come from them. And Lord Justice Patton made that remark in Fulham. I thought I might just give you the reference if I can find it. I've lost it now, but I'll get it tomorrow. It's paragraph 41 of Fulham. Page 2069. Is it?
I should say that if it suits you better for us to adjourn now and for you to have a clean run at arbitrability tomorrow morning, we're content to rise a couple of minutes early. It's a matter for you.
No, absolutely not. I want to
Very
go
well.
every minute I can.
Very well.
If you don't mind.
Of course.
I was simply going to say that we've set out our tests on, and I don't think there's much difference between us. My own friend and I agree that there's a question of construction. You construe the legislative scheme. You can do that, as Lord Justice Longmore said in Fulham, either on an implied basis or express basis. You're never going to find it as an express statement in any legislation that we can't have an arbitration. There's always going to be implied, effectively, if it's a question of construction. Public policy, I accept, is rare. We've made the argument. I'll develop it shortly tomorrow. What I was going to do is tomorrow is go through some of the principles that govern winding up petitions, because it's after all that you're being asked to say is arbitrable. And my learned friend really didn't do that. With great respect to him, he didn't have time. I'm not going to have time to go through all the arbitration cases, so he's safe there. But I'm going to do that tomorrow, if I might. And I'd like you, when I make my submissions tomorrow, to remember the background to the liberal approach to arbitration, that really everywhere we see Lord Hoffman quoted in Fiona Trust. We know that was the start of the liberal approach to construction, but what we should have in mind is the rational businessman. What would the rational businessman have really expected the outcome of this application to be? I mean, is it really the case when my learned friend says tough every time there's a problem? That's just hard luck, hard cheese. That's what the rational businessman would have found acceptable. Some of the extreme comments about arbitrability that come from mainly first instance judges appear to have lost sight of that. So maybe I can finish on that note.
Well, we'll adjourn then for the day and resume at 10:30 tomorrow morning.